What's up everybody, welcome to money management channel. My name is Andrei and today I'm gonna be doing an update on MMTLP and FINRA saga.
I got the cash in the bag, stadium packed. Born a rock star in this life, gonna live it up.
And on today's video, guys, I will show you the update from Scott Roth in regards to his lawsuit. And I have to admit that FINRA, for now, in my opinion, is scared to death because of the most recent update. And I will show you why I think so within just several minutes. On top of that, guys, I will show you an update from John Burda in regards to his flamethrower, the company that was established back in I guess 2023, at the very beginning of 2023, in order to fight against the illegal actions. And this company was created specifically to make this happen. And this company hired Wes Christian in order to make this investigation. Unfortunately, I have to admit that this company is dead. And John finally explained what is happening with this company, and I have to admit that we shouldn't rely on this path at all. So, and before we dive deep into all of this, guys, please hit the like button for YouTube algorithm and drop me a line in the comment section if you think my videos are valuable for you. And I want to begin today's video with this tweet that was written by Susan Trimbath and that was reposted by John Burda. It is a very interesting explanation of failures to deliver. And let me quote this. I frequently compare fails to deliver stock settlement fails to a game of musical chairs, or as I call it, musical shares. In musical shares, as long as new money keeps flowing in, everything looks fine. Once the money stops, and this is where allowing settlement fails, FTD is like enabling a Ponzi scheme. Someone ends up without shares. When the global financial markets collapsed in 2008, lots of people found out that they did not have a seat. Governments around the world bailed out banks and brokers, leaving taxpayers burdened with public debt. Individual investors and household investors are 8 times more likely to be holding phantom shares, the receiving end of a failure to deliver, in their brokerage account than institutions, including other banks and brokers. So, and I have to admit that it is quite interesting analogy, and I have to admit that I agree for 100% that this game will last only when the money keeps flowing in. And guys, you have to keep in mind that failures to deliver, the value of these failure to deliver stocks for now is increasing in the books of hedge funds and market makers. That is why this problem also needs to be fixed, and this should be done by authorities. Unfortunately, authorities don't want to do it for quite a long period of time, and we are here to make this happen in order to have fair and transparent markets. So, guys, and let's take a look at some news that might be more interesting for you as an MMTLP shareholders. First of all, I want to pay attention to the tweet that was written by RareDD on December 16th, and then we have an answer of John Burda in regards to this tweet, and I have to admit that this answer is quite interesting. On top of that, guys, I have even more interesting information that is related to John Burda's recent activity. But first of all, let's start with this one. RareDD wrote this: while many in the MMTLP community incorrectly refer to the Series A preferred shares becoming tradable as so-called illegal, we later learned of the exemption that made it possible. Exemption aside, the information used in order to rely on the exemption was incorrect and outdated. This constitutes fraud, a violation of Section 10b-5 of the Securities and Exchange Act of 1934. This rule prohibits specific types of fraudulent activities, including making material misrepresentations or omissions. So, while FINRA could say that they didn't check the validity of the information submitted to get MMTLP trading when the exemption was relied upon, FINRA can't say that they weren't made aware shortly afterwards. And here is this statement of George Polycross. I think this is a part of his filing in response to the lawsuit that was filed against him, John Burda, and Metamaterials. And in section 15 he wrote this on October, and by the way guys, he confirmed that he can made the same statements under the oath. This means you can rely on this information from George Palikars. So, on October the 7th of 2021, Metas management responded to FINRA's letter via email and strenuously objected to the assignment of this new symbol in light of the false and misleading information regarding it and metamaterials that was published on the OTC Markets website. We further requested that FINRA provide the company with the contact information of the individuals or groups that requested the assignment of the symbol and requested that the profile information shown on the OTC Markets site be immediately deleted and corrected to reflect the readily available information for Meta 2, which was contained in our Form 10Q filing for the quarter that has ended June 30th, 2021. So guys, this is the statement which leads me to the conclusion that George Palikars tried to prevent the trading of MMTLP stock, but something went wrong. And for now, let's take a look at the response of it is not a response, it is just the document that was also written at that moment by the attorney. So, John Burda wrote, I too was confused after hearing TZ and RS pontificate about the 3810 exemption. So I asked. Here is the response from the attorney who wrote the document. John, I'm assuming you are referring to the language below from page B90, which is a rep from the arrangement agreement. The RTO acquirer certificate of designation is in a form which complies with Nevada law and when filed will constitute the valid RTO acquirer certificate designation under Nevada law. The dividend of RTO acquirer preferred stock to be declared prior to the effective time will be exempt from registration under all applicable securities laws. If so, all that means is the issuance of the dividend or preferred shares didn't have to be registered. In other words, we didn't have to file NS1 or other registration statement to issue the preferred shares. Those shares were issued under a no-sale theory because no consideration was received from the TRCH stockholders in exchange for the shares. The rep doesn't say anything about the shares not being restricted. In fact, in most cases, shares that are issued pursuant to an exemption from registration are restricted. 3810 is a special case where the recipients can get unrestricted shares in an unregistered transaction, but that is not typical. The risk factor below is on point. The Series A preferred stock will not be listed or traded on any exchange and will not be registered and will not be freely transferable unless such shares are thereafter registered or are saleable pursuant to an applicable exemption from registration. And this is quite interesting statement. The Series A preferred stock to be issued by Torchlight to holders of record of Torchlight shares as of the Series A preferred record date will not be listed or traded on any exchange. No market is expected to develop for the Series A preferred stock in the foreseeable future, and holders of the Series A preferred stock may not be able to find a buyer and sell their shares if they desire to do so. Additionally, the Series A preferred stock to be issued by Torchlight to holders of a record of Torchlight shares as of the Series A preferred record date will not be registered under the Securities Act. Holders of a Series A preferred stock may not be able to sell, liquidate, or transfer such Series A preferred stock unless such shares are registered for sale with the SEC, which we do not expect will happen, or if an exemption from registration applies. And guys, I have to say that this is the answer from an attorney, and definitely John Burda had to use an opinion of professionals in order to understand the actions behind the scenes, and he made it, and here is the answer. And I think it is very important to understand his thoughts and his actions. At the same time, guys, take a look right here. The most important part of today's video is this question. Josephine Rikin wrote this: what is the update with flamethrower? And John Burda responded, guys, it is for the first time for almost 2 years when John Burda answered this question. So he wrote this: Flamethrower was organized to fund potential litigation and discovery on the issues relating to MMTLP and next breach. After spending a lot of money and time on attorneys and also funding consultants to get information, it was determined that only MMAT had standing to get information and develop a case at that time. George Palikros was always helpful, but his board did not want him to cooperate, as they were not believers in the impropriety in MMTLP and next breach, and for that matter MMAT. In my opinion, George lost his job because he stuck his neck out to get info to help the MMTLP holders and MMAT holders. And again, this is very interesting and important statement. Flamethrower had to yield to MMAT as they were in control, and Wes and his team are on the case for the benefit of MMAT holders, and hopefully some share count info on MMTLP and next breach holders too. So guys, I have to admit that on the one hand it clarifies at least in some manner the situation around flamethrower, but at the same time, guys, it is difficult to understand how it is even possible that if the investigation is ongoing in regards to MMTLP shares, and why in the world MMAT prevented to do so. And why in the world MMAT board of directors did not want to cooperate in this case? It also raises new questions, and one of the main questions, why didn't John and George file lawsuit against the members of board of directors of MMAT? Again, more questions without answers, but at least for now, guys, we know that flamethrower is pretty much dead, and Wes is working on MMAT issue, and it is less likely that he will find something in regards to MMTLP and the next breach hydrocarbons. So it is what it is, and definitely we have to move forward. And for now, guys, I have to admit that we have an update from Scott, and this update shows that potentially FINRA is scared to death. And guys, again, this tweet is written in not, let's put it this way, in the manner that is not so polite, but guys, forgive me, I will quote you it in its entirety. So he wrote, "The Space Queen are about as close as you can get in the entire MMTLP fiasco to the mainstream media. When you look at the battlefield objectively here, and they are about as discredited as CNN, as MSNBC and ABC when it comes to fairly and accurately reporting or anything going on with MMTLP, as the market makers are at reporting anything to do with Donald Trump or MAGA, or the political realignment that just took place on November the 5th. Forget for a moment that they exist in an echo chamber where preaching the same party line for 2 years has obviously accomplished nothing, especially when their so-called audience is obviously both formed to death, or are people who think that just one more congressional letter or meme will fix everything. Take the court cases or just mine in particular. As of now, FINRA has requested, and I have granted them extra time and pages to respond to my second amended complaint. So, despite due diligence running his spy hole to the contrary, and to his foreign audience of low brows, some of whom have been given so-called litigation hold letters to preserve their records in anticipation of being called as witnesses, as conmen or worse, for them being added as the defendants in at least Anna Trade's case in Florida. So guys, this is one of the most important updates that some of MMTLP community members potentially received letters that they have to protect, they have to preserve their records, and they will be called as witnesses. In the case of Anna Trades that was filed with the help of Mark Basile. So, let me go to further. Guzzling that Kool-Aid like an Arab hitting a Sahara watering hole after 2 weeks in the sand. The Vermont case is very much alive. All of the cases filed on or about December the 9th of 2024 also clone parts of my case by 1. Challenging FINRA's existence with declaratory judgment actions, and 2. Challenging the Private Securities Litigation Reform Act PSLRA 1995 that essentially blocks court access to retail investors and insulates the hedges, market makers and brokers from lawsuits. It's done that way by design. That puts the whole house of cards at risk for brand X. So, while fruitcakes like Metaguy Murdoch host space call number 245 and Junk Savvy is on the phone with McCabe, it would seem just before anything comes from NextBridge Hydrocarbons, folks like Daniel Oxer are going into U.S. District Court in Texas to get resolution. The big question for Julie Jane and Jamie Garcia is, what happened to that relentlessly promote flamethrower there, folks? She was all over that until the Overton window closed up. Yep, Warsaw Bernstein LLP was in February 2023 going to get to the bottom of the naked shorts with the help from Burda and McCabe, and then it quietly died. What happened? And guys, this tweet was written before the answer of John Burda in regards to flamethrower. That is why at that moment Scott didn't know about the most recent update in regards to flamethrower itself. So, my thoughts are, Burda and McCabe played the long game and then went short knowing the U3 trade halt was looming, and flamethrower was paid to show activity and go nowhere by design. Warsaw won't answer any emails, folks. Never mind that Jay and Garcia and other space queens pushed people to get into ST and they are trapped unless a judge orders them out. And guys, Scott also knows about the possibility to remove your shares from AST and to transfer them back to your brokerage accounts. And this might be the result of the judge's decision. And guys, by the way, I covered it in the video that I made several months ago, and the information at that video was based on the Rosa Towels information that she mentioned in one of her videos. You can find her YouTube channel and you can see the video. It was some kind of live stream video where she explains that the shares that were transferred to ST might be removed, might be transferred back based on the judge's order. So let me quote you further. I'm trying to do that with the writ of mandamus while these bottom feeders attack anyone in court. So, as you can see, Scott is trying to help you to withdraw your shares from AST and to transfer it back to your broker account. And this is, guys, in my opinion, this is an important fact that despite all the problems and all the hate that he faced in the public space, Scott is still working to help the entire MMTLP community. And in my opinion, it is very important. So, he also wrote this. As the saying goes, look at not their words, but their deeds. Did you all really think one more emergency space call will get your money back? Or somebody gets a hit in a US District Court in Texas, Vermont, Connecticut or Maryland? Metaguy Murdoch and Junk Savvy talk about the people filing lawsuit in the negative. It's important to remember that these bargaining basement street hustlers have never ever looked at Burda and McCabe or Clinton plant except as heroes for ripping off retail. Always busy brands is the same. though he has also burned people working for us, and he is the most snake-like of the bunch. Everyone I have interviewed about this guy tells the same story, that he wanted to be in the know about everyone's activities, and as soon as he was brought into confidences by people lobbying in Washington DC, those offices became closed doors because he was running his own campaign against anyone but McCabe Burda loyalists representing the community in DC. So guys, very interesting statement, and I have to admit that this information is really mind-blowing, because we have an update in regards to flamethrower, we have an update in regards to Scott Roth's lawsuit, and you can see that FINRA asks him to grant them extra time and pages to respond to his second amended complaint. This means, guys, they have to do something in order to protect their position, and definitely this shows that Scott is working hard and he achieved a lot. He already achieved a lot in this case, and guys, time will tell when and what type of resolution we will have, but definitely, in my personal opinion, the resolution will come through litigation processes. For now, I see it more prominent way among any other ways that we have on the table right now.
And guys, let me tell you my personal story. I have a wife and 2 children aged 11 and 15, as well as a small dog. After 30 years of living in Russia near the Baikal Lake, we decided to move. Now we reside in Serbia. Although I don't own any MMTLP shares, I invest a lot of time creating daily MMTLP videos. I have been doing this every day without days off and holidays for more than 1.5 years. Now I wish to buy back this time from my family, from my children. We've agreed that I will ask the MMTLP community to support me, and I will give all the money to the children. Therefore, if you believe that I am providing useful content for you and wish to support me, you can join my Patreon account. For $5 a month, I will add your name to my list of supporters if you wish. Thank you in advance. The link you can find in the description below. So, I think that's all information that I want to provide you. If you like my video, please hit the like button and subscribe to my channel, and see you guys and girls next time. Bye!
I got the cash in the bag, stadium packed. Born a rock star in this life, gone live it up on the attack. Baby, I'm bad, I just want